The mayor's former communication director, Irene McCormick Jackson, is the only woman who's come forward so far to file a lawsuit. Meanwhile, the city attorney's office prepares to file a countersuit to recoup legal fees from the mayor. And criminal investigations may move forward as a result of the San Diego Sheriff's sexual harassment hotline. Here to help put this in context and what we might expect next is employment law attorney Dan Eaton. Dan, welcome back.
Sure, nice to see you, Peggy.
Now, Mayor Filner's attorney basically asked for a change of venue from San Diego County to Imperial County. What evidence if any, is needed to make this happen, and how hard is it to get this change of venue?
Well, let's be clear about what we're talking about. Change of venue means change of place, and the basis on which the mayor's attorney is seeking this is that an impartial jury cannot be assembled. So the kind of evidence that he has introduced, evidence about polls showing how many San Diegans have made up their minds about this in the 70+%, the number of media mentions, 238 in San Diego media versus 6 in the Imperial County in their newspaper of record, almost 40 on KPBS alone, by the way. So this is the kind of evidence they're marshaling.
37 to be exact.
Well, 37, okay. But it's a tough thing to do. And the fact is that when you look at the past, the last big city mayor to try this was Kwame Kilpatrick out of Detroit. And federal judge said, no, we're not moving it out of Wayne County there. Closer to home, in 2002, Kristen Rawson, the toxicologist who was accused of poisoning her husband, tried to do it, and the judge said no.
So not easy, not likely to go.
Very hard.
Okay, the mayor is scheduled to give his deposition this Friday, but his attorney filed a motion to, quote, quash the subpoena. What does that mean?
It means that he's saying the deposition cannot go forward on the scheduled date until the judge decides when it should go forward. And what the mayor is asking for, I've read the moving papers that the mayor's attorney filed, is that the deposition take place no sooner than 30 days after he was served. So it's going to take place probably sometime in September or early October. It's just not going to take place on the 9th.
Okay, what qualifies as sexual harassment under California law? Does it have to take place in the workplace?
Well, it doesn't have to take place in the workplace, but whether it takes place in the workplace or not, the plaintiff has to show that the conduct was severe or pervasive, both from her perspective and from the perspective of a reasonable woman in her similar condition. So the fact is that it is a very tough standard. And as far as it not being in the workplace, there are only certain kinds of relationships where people outside of the workplace can sue for sexual harassment, such as attorney-client, teacher-student, or the statute says similar kinds of relationships.
More than a dozen women have come forward now making these allegations. Is there a statute of limitation on filing sexual harassment claim? Because some of those women, it dates back to when he was a congressman.
Right, and yes, there is. When we're talking about outside of the workplace, under the California law that we are talking about, you're talking about a 2-year statute of limitation. And then, of course, the workplace harassment statute has its own particular statute of limitation. So a lot of these are probably time barred. There's more political pressure than legal pressure that's being brought to bear on these other claims.
So 2 years, typically?
For outside of the workplace,
I see.
Understand.
Okay. How about, could these women all get together and file a class action lawsuit?
Hard to see how a class action would work, because you'd have to show that it's capable of being proven by common proof. Given the variety of the different kinds of claims, even assuming that a lot of them are not time barred and you can get over the relationship issue that you have to establish, it's pretty hard to see this going forward as a class action. That doesn't mean that Irene McCormick Jackson is going to be the last of the lawsuits that will be filed.
Okay. How are sexual harassment cases typically settled?
Well, typically they're settled through mediation, and then eventually one party or the other pays. In this case, it's going to be tough to see how that goes forward, and one of the conditions of settlement may very well be that the mayor resigns. And so far, at least, he's adamant that he's not willing to do that. All
right. Now, many of these alleged incidents, as we said, occurred while the mayor was actually a Congress member. Are Congress members subject to sexual harassment?
Well, they are now. The Congressional Accountability Act of 1995 made Congress people subject to Title VII, which is the federal anti-discrimination law. That was enacted in January of 1995 when Mayor Filner was beginning his second term, and it passed the House of Representatives 390-0.
Did he vote for it?
He did. He was one of those who was there, and he voted yes.
All right. Well, we'll have continuing coverage on our website, kpbs.org. Employment law attorney Dan Eaton, thanks very much.
Sure. Thank you.